Welcome to Law Minds. Today we'll be seeing about Parsi Intestate Succession and non-Parsi Intestate Succession certificate under Muslim law. Before moving on to the topic, we'll see what succession means. So, succession law is also known as inheritance law, and it plays an important role in governing the transfer of property and assets from one generation to the next generation, or from a deceased individual to his legal heirs. So, their legal framework is designed to ensure an orderly and fair distribution of wealth among the heirs or people who are entitled to that particular property. There are two types of succession. One is testamentary succession, where the deceased person has left a will and the distribution of property occurs in accordance with the wishes expressed in that particular will. In case of intestate succession, the deceased did not leave behind a will, or if the bequest of property in the will is for some illegal or immoral purposes, then the distribution of the deceased property follows the laws applicable to succession, which in India is influenced by the religion followed by the deceased at the time of their death. We'll move on to Parsi Intestate Succession now. So, in matters of succession, Parsis have followed various customary laws till the codification of laws during the British times in 1865. As per these customs, Parsi Panchayat, which is also called Parsi Anjuman, they were given the authority to pass jurisdiction on matters related to succession, land disputes, domestic conflicts, etc. So the composition of these panchayats would be influential persons from the Parsi community. And after that, in India, after independence and all, Parsis started following a specific succession laws based on their religion and personal status. For interstate succession, the provisions under section 50 to 56 of the Indian Succession Act 1925 are applicable to Parsis. These sections outline the rules for distributing the deceased person's property among his or her legal heirs. For testamentary disposition, Parsis are governed by the provisions of Part 6 of the Indian Succession Act 1925. This part of the law deals with the creation, execution and interpretation of wills, including those made by Parsis. We'll move on to basic principles of intestate succession in case of Parsis now. Section 50 of Parsi Marriage and Divorce Act deals with it. So there are certain basic principles regarding to intestate succession among Parsis. First of all, the property of an intestate Parsi, it has to be distributed among his or her legal heirs according to the rules of Parsi personal law only. And then the heirs are classified into two categories. One is sharers, another one is residuaries. So the sharers are the people who are entitled to a share in the property, and the remaining left out property will go to the residuaries. So the heirs are determined based on the order of priority only, which is as follows. First in the priority chain is spouse, and the next are children and parents and brothers and sisters and other relatives. In cases where there are no legal heirs at all, then the property shall be transferred to Parsi Panchayat of the locality where the deceased resided at the time of his lifetime. Children born after the death of intestate are also considered as legal heirs, but there is a condition. This particular child must have been conceived before the death of the intestate. If a lineal descendant dies before the intestate without leaving a spouse or children, they shall be disregarded in the distribution of the property. Example, a son who is unmarried dies before the father, then that particular son will be disregarded in case of Parsi intestate succession. If the widow of a lineal descendant, in case that particular son is married and has a widow or a child, then the property belonging to him, the property to which he is entitled, will be shared by his widow and the children of the lineal descendant. So next we'll move on to provisions dealing with intestate succession among Parsis under the Indian Succession Act 1925. From section 51 to section 56 of Indian Succession Act deals with it. There are various rules, and the rules vary depending on the familial circumstances. So first, section 51 it says that when a Parsi dies leaving behind a widow or widower and children, but there is no parents. So there is only widow and children, but there is no parents. In that case, each child and widow will receive equal shares. In case where the Parsi dies leaving children, but there is no widow or widower and there is no parents, there is only children, then the property will be divided amongst the children in equal shares. In case the Parsi dies leaving behind one or both parents along with children and widower. So in this case, one or both parents is also alive, children is also alive, widow is also alive. In this case, the parent or both the parents shall receive a share equal to half the share of each child. Section 52 has been repealed and is no longer in effect. Section 53 says that it gives specific rules for dividing the share of a predeceased child. So, if an intestate dies leaving a deceased son, widow and children of that particular deceased son take shares as if he had died immediately after the intestate's death. So, the widow and the children are entitled, even though the son has been deceased before the intestate. The widow and children of the deceased son will be entitled to the share that the deceased son was entitled to. If an intestate dies leaving a deceased daughter, then the share of the daughter is divided equally among her children. If any child of the deceased child has also died, then his or her share shall also be divided in like manner following the rules applicable to the predeceased son or daughter. And then in case of a remote or lineal descendant has died, then provisions set out in section 2 subclause C shall apply mutatis mutandis to the division of any share to which he or she would have been entitled to. Now let's move on to section 54, which is an important section. It outlines rules when there are no lineal descendants but a surviving widow or widower of the intestate. So in this case, there are two circumstances. One, where there is no son at all, no lineal descendant at all. And the second case, where the lineal descendant has died or predeceased the intestate. So first one, if the intestate Parsi has no lineal descendants at all but leaves behind a widow or widower, then section 54 specifies that the widow or widower shall receive half of the estate with the remaining portion distributed as outlined in the act. In case where the intestate Parsi leaves no lineal descendants but is survived by a widow or widower, so lineal descendant is also dead here, but the intestate Parsi, he has a surviving widow or widower, or the widow of the lineal descendant is also alive, then section 54 governs the distribution. It mandates that 1/3 of the estate goes to the widow or widower of the intestate, 1/3 goes to widow or widower of the lineal descendant, that is the son, and the remaining 1/3 is distributed according to the act. In case where intestate Parsi has no lineal descendant and no widow or widower but leaves one widow or widower of the lineal descendants. In this case, the wife is also dead, the son is also dead, but the son's wife, who is a widow, that is she is called as widow or widower of lineal descendant, that person alone is alive, then section 54 mandates that the widow or widower of the lineal descendant receives 1/3 of the estate with the remaining 2/3 distributed as specified. In case where intestate Parsi has no lineal descendants, no widow or widower, but leaves more than one widow or widower of lineal descendants. So here the sons, say there are 2 or more sons, everyone is dead, and then the widow of the intestate also is dead, but the widow or widower of the lineal descendant, the wives of his sons are still alive, then section 54 says that the widows or widowers of the lineal descendants together receive 2/3 of the estate divided equally, and the remaining will be distributed accordingly. So following the distribution as mentioned above, any residue is to be distributed. These subclause E talks about the residuary I talked before. So any residue is there, then that will be distributed as outlined in schedule 2 part 1. male and female relatives in the same degree shall receive equal shares only. And if there are no relatives entitled to the residue at all, then the entire residue shall be distributed among persons entitled to receive share under the section in proportion to the specified shares. That is, if there is no residue, then the person who are entitled, they will receive it. Then let's move on to section 55. If the Parsi dies intestate, leaving behind no widow or widower, no lineal descendant, no widow of any lineal descendant. So no one is alive now. The wife is not alive, the son is not alive, the son's wife is also not alive, no one's alive. In this case, the whole of the property of the intestate shall be succeeded to the next of kin. Because there is no one alive here, so it will go to the next of kin in manner defined in Schedule 2, Part 2 of the Act. Section 56 says that when no relative entitled to succeed under the other provisions of Chapter 3 of Part 5, in which a party has died intestate, then the property shall be shared equally by the intestate's kindred who are at the nearest degree to him. Like when there is no wife, no son, no widow of the lineal descendant, no next to kin to, then in that circumstance, the relative who is the nearest degree to him will get the property. That is what Section 56 says. These rules provide a comprehensive framework for the distribution of property among Parsis in India who have passed away intestate, covering various scenarios and ensuring a fair distribution among eligible heirs and next of kin. These sections collectively govern the distribution of property in case of intestacy among Parsis in India. Now we'll move on to non-Parsis intestate succession. The rule of succession for non-Parsi, which include Europeans and Indian Christians, are specific and separate from laws governing other communities like Hindus and Muslims. For Hindus and Muslims, there are specific laws governing these kind of things in India. And for Europeans and Indian Christians, the rule of succession is separate from the laws governing those communities. So these rules are detailed in section 31 to 48 of the Indian Succession Act itself. First one is devolution. The property of the intestate will go to the spouse, or in absence of spouse, it will go to the kindred. Kindred means nothing but relatives. So widow share. If there are lineal descendants, if there are children, then the widow is entitled to 1/3 of the property, while the children or lineal descendant will receive 2/3, equally distributed. And in case of widow and kindred, if there are no lineal descendants at all, but there are relatives, then the property is divided equally between the widow and the kindred. And in case where there is no widow, no lineal descendant, no kindred, there is no one alive right now, then in this scenario, the property will go to the government. And similar to the widow, the widower, the husband also receives the same share as the widow if there are no lineal descendants. That is, the widower gets a full share. In case where the wife is dead, her property will go to the lineal descendants or someone like that. In case where there are no lineal descendants at all, then the wife's property will go to her spouse, that is the husband. So in case of children, if there is only one child, that child receives the full share. If there are multiple child, it has to be divided equally between the multiple children. And grandchildren, in the absence of children, if there are grandchildren, then they share the property equally too. And there is no one else but the father is the only person who is alive now, then he will be entitled to the full property because there is no one there to share it. And then if there is no widow, lineal descendants or kindred, the property is equally divided among the mother, sister and brothers too. So these rules ensure a systematic and fair distribution of property among non-Parsi individuals who pass away intestate, taking into account various family relationships and scenarios. We'll move on to succession certificate. First of all, what is a succession certificate? An intestate individual is someone who passes away without creating a will, or he created a will for some kind of illegal or immoral purpose, right? So in such situations, the court steps in to issue a succession certificate to the legal heirs of the deceased person. This legal heir needs a succession certificate to get the property of their father or mother. So the certificate grants the holder the authority to settle the deceased debts and assets, and it also offers protection to anyone owed money by the deceased. So if there is any kind of debt or loan, then the person who undertakes this authority has to pay it. And also if there is any kind of advantage, like anyone is entitled or obligated to give money to these particular intestate, then it will be received by the person who takes the authority to. So there is a benefit and also a drawback here. A succession certificate is particularly important if there are disputes among legal heirs, because in most cases, in cases of intestate succession, mostly the legal heirs start to fight. The people who are entitled to the property start to fight, because everyone wants property, but the law doesn't give property to everyone. It only gives property as per the priority. So by priority, legal heir gets the property. They have the utmost priority. So if there are disputes among legal heirs over ownership or possession of the deceased person's assets, and it may become necessary for legal proceeding, this particular succession certificate is very important in case of disputes like that. Also, when it comes to an immovable property, even if there are no disputes at all, it is mandatory for a legal heir to have succession certificate. To obtain a succession certificate, a person must file a petition in district judge. This district judge should be of the appropriate jurisdiction, that is, it must be within the jurisdiction of the deceased person. So under Indian Succession Act, the district judge is authorized to issue a document known as succession certificate. This particular certificate will have the following details as laid down here: the date of the deceased person's death, usual residence, where they were staying before the time of death, and information about the deceased family and other close relatives, petitioner's legal right to make this claim, whether they are actually entitled to make this claim or not, specific details about debts and securities which requires the certificate, and confirmation that there are no legal impediments to issue the certificate, and so on. So these details has to be laid down. Importantly, there is no specified time limit within which the application must be made. So it can be made anytime the legal heir wants it. So to conclude, succession law is a fundamental aspect of our legal system that governs the transfer of property and assets across generations. It ensures that property is passed down according to the desires of the deceased within the confines of legal norms. And also, India is a country with diverse religions, and our constitution has given equal rights to all religions. But to keep pace with the multiplicity of succession laws can be quite confusing and tedious for the common man as well as law enforcers. As societies evolve, succession laws continue to adapt to meet the changing needs and values of diverse communities, emphasizing the importance of this area of law and maintaining social and economic stability. Thank you.